name is Stephanie Rapp, and I work as assistant professor at Leiden University, the Department of Child Law. And my presentation today is about the right to effective participation of refugee and migrant children. And I will present today the preliminary findings of my research that I conducted over the past 3 years. The starting point of my research is the right to participation for children, which is an overarching term that can be found in the CRC, not specifically, but the right to participation is usually seen as part of the right to be heard, among other children's rights. So the right to be heard, as stated in Article 12 of the CRC, states that all children have the right to give their views and opinions on all important decisions that are taken in their lives. And it really also shows that children are bearers of rights and that children should have the opportunity to also have their views heard by professionals who take decisions in their lives. This is also the case for children who are participants in migration proceedings. And the CRC committee has stated that special attention should be given to the right to be heard for children who are part of immigration, asylum, or refugee proceedings. And this also holds true for children who are accompanied by their parents. And according to the CRC committee, they should also be separately heard from their parents. It is commonly acknowledged that the right to information is an important part of the right to be heard and the right to participation, because information is needed for children to be able to participate in specific proceedings. And this means, for example, that children should be given explanations on the type of procedure that they are involved in, and what is expected from the child in that proceedings, and also about the possible decisions that could be taken and the consequences of these decisions for children. Of course, children should also be assisted in proceedings in order to help them participate, for example, by a legal advisor, but also by other people who can support them throughout the proceedings. And in my research, I've looked at how this right to participation is conceptualized in practice, specifically for children who are refugees or migrants in the Netherlands. First, I've also looked at what we know from other research on child participation in legal proceedings, but also specifically in migration proceedings. Previous studies indicate that children find it important to be heard in the proceedings that they are part of. And also positive influence is coming from their participation with regard to their self-confidence, self-esteem, feeling in control over the decisions that are taken in their lives, and giving them also feelings of autonomy. So these are also important positive influences of participation. And also another aspect of it is that they also better understand decisions that are taken in their lives if they are able to participate and when they are heard by the decision maker themselves. They also state that it is important for them in several studies that the decision maker in the case hears them and not through a representative or sort of indirect representation. On the other hand, it is also visible from a lot of research that children indicate that they would like to have more information, that they do not always know what is expected from them or what the procedure is exactly about and what kind of decision will be taken. So they feel that they can be given more information before the start of the proceedings. And also children report that sometimes they feel that they are not treated in a respectful way by professionals, and that they also do not understand all the legal language that is discussed. So these are things that can still be improved in practice. Specifically in relation to children in migration, the lack of information is very much visible in research because these children come from other countries. They do not really know what to expect when they arrive in a new country and what kind of proceedings will be followed when applying for asylum. And also they display a lack of trust in professionals and social workers even, because they don't know yeah, to what extent they can open up and explain their situation, because they have to apply for asylum. And yeah, this is a very yeah, insecure situation for them. For accompanied children, we already see from research that they are very much depending on their parents. Parents are informed about the proceedings, and children depend on the parents for the information that they receive and yeah, the extent of involvement in the proceedings. Regarding my study, over the last 3 years, I've conducted first interviews with professionals who work in the migration system in the Netherlands. I've spoken to 42 participants in in-depth interviews. The second part, I conducted observations of interviews that immigration authorities had with children below the age of 12. Those interviews are videotaped, and I was able to observe these video interviews, 13 in total. And the part that's still ongoing are the interviews that I am conducting with children and young people who have applied for asylum in the Netherlands or are still in the process of applying for asylum. And so far I've spoken to 18 different young people about their proceedings and how they experience those. From the interviews with professionals, I've looked at, again, the aspect of information and participation. And I've looked at different roles in the proceedings. So I've looked at or interviewed people who are immigration officers. And on the other hand, I also looked and interviewed people who are more support persons for young people, like lawyers, for example, and guardians, and other people who support young people throughout the proceedings. And for the first part about information, you can see that from the start of the proceedings, different people are involved in providing information. For unaccompanied children, the guardian is an important person for the unaccompanied child, because that person really has to provide all the information and is the first point of contact for the child. And a lawyer yeah, comes into play later in the proceedings when the actual interviews with the immigration authorities will start. Another organization in the Netherlands that is involved in providing information is the Dutch Council for Refugees. And this organization has the legal obligation, and also is funded by the state, to provide refugees and migrants with information on the proceedings. And they also do that for children, for unaccompanied children and accompanied children. Also, they have developed some projects to inform them about the proceedings and also about wider aspects of children's rights and life in the Netherlands as well. But it appears from the interviews that they do not reach all children, and specifically not the children who are accompanied by their parents. I've also asked about whether participants think that young people and children are prepared well enough to be able to be interviewed. And most of them think that there's quite some preparation given to children and young people. But also it depends on their age, their level of development, and also the level of education that they have and have had in the country of origin as well. So some respondents also said that, yeah, with regard to unaccompanied children, those are mainly teenagers, and some of them, yeah, are convinced that they will receive a positive application in the end. So they do not really prepare so well, and only, yeah, understand the seriousness of being interviewed once they arrive at the immigration office. But it really depends on the individual situation also. When looking at participation itself, yeah, it is agreed among all participants of this research that children should be able to tell their own story. But specifically, lawyers and guardians explain that they see that a way of meaningful participation is very difficult in this type of proceedings for children. The immigration officers indicate that they need information from children, that they need to engage in fact-finding or truth-finding, and that therefore they have to ask certain questions. And the lawyers and guardians explain that this is not really a way of participation in which children can really explain their own story and their own views to the immigration officials. This also depends again on the age, the level of education, and also the cultural background of the child. And also some people explain that, it's a Western concept, maybe participation, and to what extent can we expect these children to really participate. The immigration officers indicate that they make special adaptations for children in the interviews by explaining the purpose of the interview, taking breaks, and also not laying too much pressure on the child, and also not giving too much attention to credibility, and also comparing the story of the child to those of parents, for example, when we talk about accompanied children. On accompanied children, they are only heard in the proceedings when they're 15 years or older. And then their parents are interviewed, and they themselves are also interviewed in separate interviews. It should be stated that in that way, in these kind of proceedings, it can be possible to compare the story of the child with those of the parents. And also the legal position is less well developed of the accompanied children. They do not have a separate lawyer or a support person, for example. And in many interviews, they are alone, and there is no one else for support available for them. Then when looking at the child interviews that I observed, those are with younger children below the age of 12, and they are conducted in a special child-friendly interview room of the immigration authorities. The interviews that I've seen lasted on average 49 minutes. The room also contains special props and tools, for example, like a chalkboard, a podium with dots on it, drawing paper, picture books, and puzzles that could be used by the immigration officers to really have a conversation with the child, and to try to facilitate a better conversation. On average, these interviews lasted 49 minutes, and also breaks were taken in between. From the analysis of these videos, I looked at to what extent children are given explanations and preparations to the content of the interview, and also what kind of conversation techniques that were used. The preparations mainly revolved around explaining to the child that the interview is videotaped, that there is an audio-visual link to another room where the guardian was able to sit and look at the interview. So more technical details were discussed, but a thorough explanation of the aim of the interview, the ground rules for conversation, and what was expected from the child, and also the follow-up was not very much in detail discussed with the child. So in several of these interviews, I also saw that the child at the end of the interview asked about the outcome of the procedure, and when they would hear something, or what would be the outcome in the end. And this was not addressed self-evidently by the immigration officer, and the child had to ask it him or herself. Regarding the content of the interview, I observed that the immigration officers relied heavily on asking closed-ended questions, which were very factual in nature and also very detailed. You could see that many of these questions were very difficult to answer for specifically this group of very young children. Many of these children did not reside for a very long time in the country of origin. They had traveled and lived in several places. So I saw a lot of confusion about specific locations, places where they lived, how it looked like. And it was very difficult for these children to recall all these details. And this has also been observed in earlier research on the interviews with migrants in these kind of proceedings. In the end, I also looked at what kind of conversation techniques were used that are suitable for children. I saw that small talk was used, for example, giving the child compliments, summarizing, and also bringing the child back to the daily reality at the end of the interview. But this really differed substantially per immigration official. So not all of them use those techniques as extensively as others. And the specific tools that could be used were only used in only half of the cases, basically. And in the other half of the cases, it was mainly an interview where the child and the immigration officer were sitting at the table and having an interview. I tried to summarize my research findings in this slide. For the unaccompanied and for the accompanied children. So very briefly about information provision. In theory, a lot of information is provided to unaccompanied children, but in practice, they indicate also in the interviews that I recently had that they would like to have more information. And that they did not understand all the information that was given. For accompanied children, they largely had to depend on their parents, and not all of them are reached. Regarding participation, you can see that all unaccompanied children from the age of 6 in the Netherlands have to be interviewed by the immigration authorities. But the participation really relies on truth finding and credibility to assess whether the child needs protection or not. And it's not a real form of participation in the sense that they can tell their own story and their own, have their own authority over telling their story. Children indicate largely that the interview is a given, that they have to go through it and that they do not really have a choice in that. And for the accompanied children, they're interviewed from the age of 15, and even some of the immigration officers indicate that they do not really see the added value of hearing these children when their parents apply for asylum and they are heard. And when the child does not have a separate asylum claim, so to say, but has the same story as the parents have. And the stories can also be compared, and that makes it more difficult to assess the situation and to come to a final decision for the immigration authorities. To conclude, so the right to be heard and the idea of participation, as when we look at the CRC and the CRC committee, is given this idea of you have to hear the true, authentic voice of the child and his opinion in a child-friendly environment. But the reality of asylum proceedings is that the aim of the interview is to collect information and facts and not in fact really hear the voice of the child or hear the true opinion of the child and taking that into account. And you can also see that immigration officials and representatives of the child, on the other hand, have diverging views on that. The immigration officials try to make the interviewers more child-friendly and to take into account the age and maturity of the child, but at the end of the day they have a set of questions that they have to ask and the child has to answer these questions. Next to that, asylum proceedings are also highly complex in the way they are organized and also decisions that have to be taken. And there's also a political component of these decisions, and therefore, fact-finding has to take place. Especially from the interviews that I was able to observe, I would like to indicate that immigration officers can be better trained in using child-friendly interview techniques, at least to get some more information and to get a more natural conversation with the child in the end, because I think that's possible also for younger children, but the right techniques need to be used. I would like to conclude in saying that children are participating in these types of procedures, but especially with regard to information provision, this could be improved in the Netherlands. And yeah, critical remarks can be placed as to whether true participation is possible in these types of proceedings. Thank you very much for your attention, and I look forward to any questions from your side.
Thank you very much, Stephanie, for your fascinating presentation. There's already some questions in the chat. The first question is from Lisbeth Brink. Hi, Lisbeth. And the question is, what is the influence of interviews with immigration officers on the mental health of often traumatized children? Do you have insights on this from your research?
Now, I didn't look at it specifically. I have to think of. There is some research, but mostly on the influence of the housing situation of children on their mental health, whether they are in a reception center or in a family, for example. And then it shows that this living situation has a lot of influence. And also from practice, I hear a lot that especially the unaccompanied children, they have to live sort of independently together in a group. And there is some supervision from the people who work there, but that they are given a lot of own independence in how to have their daily routines and things like that. And that there are quite some people who are concerned about that, and that some of them are not motivated to go to school, for example, and then it's really difficult to have them involved in the formal or in the school system that they are in. But I don't know of any research specifically on the influence of these interviews on the mental health of children. And the young people I talk to often feel relieved after they had these interviews and when it's finished, because it's quite stressful. And they also almost all of them say that they do not really know what to expect because they've never been in that situation, and they find it really difficult to understand what will be asked from me. I can only tell my own story, but I think when you also hear these interviews, they are so detailed, you're sometimes very surprised about what people have to report about their own country and where they lived before.
Thank you very much.
I hope that's sort of a question, sort of an answer.
I'll take one more question, Lucy. She's asking if carrying out this trained. Are they trained to interview?
They are. To some extent, these people are trained, but not very thoroughly, I think. I was able to sit into one training for people who started working at the IND, and the training was specifically for the interviews with younger children. It was one day, so it was quite superficial, I would say, and it could be much more thoroughly. Also, when you compare that, for example, with the training that the special police officers have who interview child victims, I think much more can be done to train people who work in the immigration system, and also the social workers and things like that. It really depends on the case whether there is someone who is accompanying the child, and mostly it's the idea that the child has the interview alone with the immigration officer and an interpreter, of course, and that not a support person is present during the interview. And also for the accompanied children, mostly, they just rely on the parents to be there, but no other real support person.
Thank you, Stephanie. There's some more questions in the chat, but we have to move on. So perhaps we can respond to them in writing. We will now move to the next presentation.
Okay, so my paper is entitled "We always want to hear people are sorry, Dutch judges about culture and religion in family court cases on migrant children in the Netherlands." And first of all, I wanted to thank the organizers for organizing this really interesting workshop and giving me the opportunity to present some of this research which is very much an ongoing project. And in my presentation today, I will discuss how Dutch courts deal with cases on children from migrant families and other minorities, and how they take families' ethnic, cultural, or religious background into account when taking decisions. And as I said, it's part of an ongoing research project on the role of conceptualizations of culture, ethnicity, and religion in court cases on children. And it's mostly an ethnographic study using different methods, including an analysis of court files and court judgments, interviews with court actors such as judges and lawyers, with NGOs and child welfare social workers, as well as parents and other family members. Obviously, it has all been a bit interrupted by the whole COVID situation, so I'm still able to do some interviews, but currently I can't continue the file research I've been doing at the courts. So I hope at some point I'll be able to continue that, but it's not yet clear when. And this presentation is predominantly based on a series of interviews with judges. And the judges I interviewed were mostly working in the family division of courts of first instance. And these family divisions handle quite a wide range of different kinds of cases. They do divorce, marital property disputes, other family legal issues such as paternity. They do child protection cases, obviously, and also involuntary admissions to psychiatric hospitals, both for children and adults. And in some courts of first instance, the youth criminal cases are also handled by the family division, whereas in other courts, this is done by the criminal division. So this is a difference in organization between different courts. However, most judges don't do everything. So most children's judges or family judges tend to specialize in 2, perhaps 3 categories of cases. And the larger the court, the more specialization going on. Okay, one of the most important findings in the interviews so far is how notions of ethnicity, culture, religion are at the same time very present, as well as remarkably absent in court cases on children from migrant families and other ethnic minorities. First of all, in the Netherlands, migrant families are overrepresented in some types of cases, especially child protection cases and youth criminal cases. And it has been like that for a long time. Furthermore, as some judges explained while they were doing this, while it was doing these interviews, in the big cities like Rotterdam and Amsterdam, more than half of minor children are from ethnic minority families. So, as judges also said, this makes a court session with only white native Dutch family members a rarity, whereas in smaller courts in other regions of the Netherlands, that's very different. And in the interviews, all judges told stories, shared anecdotes about specific issues which they felt affected the cases of migrant families. And judges generally attributed these issues to either the cultural background of these families or the religious background of these families, although some of them also mentioned socioeconomic causes. And examples of categories which were mentioned repeatedly are boys of Moroccan descent involved in criminal behavior. Another pattern a lot of people mentioned was single mother families, especially with people with a background in Suriname or the Dutch Antilles, which are both former Dutch colonies for those of you who are not from the Netherlands. And another issue which came up a lot in the interviews are cases related to the sexuality of Muslim girls. And an issue that was mentioned in almost every interview with judges, as well as with lawyers, was a tendency of suspects in criminal cases who are of North African descent to deny their involvement in criminal behavior, or to remain silent during the court procedure. And judges and lawyers attributed this behavior to essentialized notions of North African shame and honor culture, where it would be shameful to confess a crime, especially in front of one's parents, and parents are obliged to attend the court hearings of minor children. At the same time, honesty, taking responsibility for one's actions are considered important values in Dutch culture, especially when children speak to adults, according to these judges. And as many judges pointed out, these conflicting values created tensions when they were dealing with criminal cases of youth of North African descent, for example. This is a quote from one of the judges I interviewed. For me, that is sometimes a frustrating exercise. To get through that, you try to take into account that such a youngster has little space to confess, but in criminal cases, we have much more space. Formally, we always have space in all cases. That's not the point. But you do have much more space to customize with someone who evidently did it and confesses. A learning sentence, for example, you can do something like that. Or something conditional, impose supervision. But with the denying suspect, it's a lot more complicated. We do it anyway, but actually it doesn't feel right. Hoping that the youth probation officer can do something after all. Sometimes this works, sometimes this doesn't, but it limits your space to do something. Let's see. And most judges I interviewed, they explained that they had been made aware of these issues by specific training courses for judges aimed at dealing with cultural diversity in their work. Nevertheless, despite all these courses, some judges still felt that this tendency of North African children to deny their involvement had an impact on the sentences they received, despite the awareness of judges and lawyers of where this behavior came from. For example, another judge said, sometimes they deny against all odds while the evidence is there. And if you fail to notice that comes from the culture or background or ethnicity or whatever, you can get irritated by that. And perhaps say, well, I will give him a higher sentence than I would normally have given. Because you keep denying, well, it's pretty obvious that you're responsible. We always want to hear people are sorry. And people can say that quite easily without meaning it. But well, I cannot really do anything about that. I cannot check the inside of people's heads to see whether they mean it. But if I think someone is truly regretting what they did, that has an impact. And that can also impact the punishment. Children do not get severe sentences, so it would not be a year or so. That can mean the difference between imprisonment or community service, or a larger suspended part, those kinds of things. And what I find really remarkable in this research is that while several judges described these kind of issues, and lawyers did as well, at the same time, these issues are almost never explicitly addressed in court. So everyone's aware of it, but no one ever discusses this. And in one of the interviews, a judge actually reflected explicitly on this silencing of difference in court cases. And she said, when I was listening to the introduction of your research, I realized we almost never raise that point in our hearings. Actually, we never speak about it, or very little. You try to look past it a bit, look at the family. But maybe you should just do it for once. What do parents think about that? You just don't ask, well, do you have certain ideas about things? I never ask that. I don't put it up for discussion because I actually feel like there's just someone sitting before you, and I just try to do what the law says I should do without regard to persons. At some point, you don't really see anymore who's sitting there. At least you don't really think about it. And then that also does not come up for discussion. And some of the lawyers I interviewed also explained that they were actually reluctant to refer to ethnic, religious, or cultural aspects of their clients' positions in court. And one lawyer who was himself also a migrant and who specialized in migration law and family law cases for migrant families. And he said, some judges want to know and understand that very well. It happens, the judges ask me. Some judges do not. Once it was important in the case, really important, that the judge in that case understood exactly the culture behind what happened. But then the judge told me, well, mister, your explanation is beautiful, but I don't need to know that. I don't need to understand. We are in the Netherlands and the culture of other countries plays no role here. I don't mean to say that culture outside our borders determines anything in here. But for you, as a judge, it's important to understand why things happen as they do. Some judges do want to know, and they listen. Unless I don't know the judge very well, then I just drop a little sentence about culture and see whether the judge reacts. If he's interested or not, well, then I can explain, or not. So as my research thus far shows, judges tend to avoid discussing culture, ethnicity, or religion in court hearings, unless parties involved in the case make explicit claims. Lawyers also tend to be reluctant to make such claims. And moreover, as some preliminary analysis of the court files has shown, even if there were claims made by family members or lawyers or perhaps child welfare workers, and they were present in the file or they were made during the hearing, they rarely ended up in the written court judgment. So if you look through the entire file, there might be mentions, but they don't end up in the judgment. So in their decision-making in all family law cases, and especially in child protection cases, the most important consideration for judges is the best interest of the child, as you will all be very familiar with. And many judges in this study aimed for what I would call a colorblind approach to the best interest of the child in their cases. Similarly to the judge I quoted before, many saw their work as applying the law without regard to persons. For example, one judge said, you know, the best interest of the child, it's also very practical. Someone just has to feel safe and he should be loved a bit. There should be food, he should be sent to school, and he should wear somewhat reasonable clothes. I never thought beforehand that it would be this basic, but it just is. And that's the same in every culture. You can give that in different ways, like what I just said about Antillean families. I try not to be difficult about that myself, about bedrooms and all of that. And early in the interview, this judge had been explaining how in some cases she handled of Antillean families, parents were criticized by social workers for sleeping in the same rooms with their children, while social workers felt children should sleep in individual bedrooms. And as this judge says here, she tries not to take such cultural differences in providing places to sleep into account in her assessment of the best interest of the child. However, she uses the term not to be difficult, which implies she seems to consider this more of a personal effort rather than a core principle of her work as a judge. And this argument was actually raised by several judges. On the one hand, they describe a whole range of differences between families of different backgrounds in how they raise their children, and they attribute these differences to culture. And they may be open to adjusting to those differences. On the other hand, they also underlined that there was like a universal bottom line of what children needed and that they were not willing to cross. Yes, and I'll come to my conclusions now. Culture, religion, and ethnicity tended to remain implicit and silently present in court cases on children, unless there are very strong reasons to address it explicitly. And even when all professionals involved were aware that conflicting values negatively impacted the legal position of migrant children, such as the example of youth of North African descent in criminal procedures who refused to admit their involvement in a crime, this was still not addressed explicitly in court hearings or judgments. And these findings fit with general research on how people in the Netherlands tend not to speak about ethnicity or race if it can be avoided. And in international critical literature on this topic, it has been argued that such color blindness silences experiences of racism and actually enables bias. And in continuing this research project, I hope to further explore these tensions. Thank you.
Thank you very much, Iris. It was really interesting, and especially all those quotes from the practitioners. Lucy has two questions. So has there been consideration to work with the youth and parents to make them feel like they're in a safe space and to take responsibility for their action, get appropriate help? The second question is, can justice officials be better sensitized on the cultural differences in order to be able to address the denials? Thank you.
Yeah, first of all, I think that many people working in the courts, and I haven't spoken to people who work in the prosecutor's office, but they might be in the same situation. They've all been to specific courses and to be educated about this issue. So a lot of people could quite easily explain what's going on and why young people do this. But that's more or less where it stops. So there's awareness, but I didn't get the impression that anyone's actually doing something about it. I know some lawyers always try to convince their clients to explain what's expected of them and convince them that it's much better to confess. Some do, but many also feel like, okay, this is kind of fruitless. It doesn't help anyway. They won't confess anyway. So it's like the elephant in the room. No one, everyone knows what's going on, but no one really mentions it or does anything about it. And the first part of the question, I'm not sure whether there's any kind of convincing people they're in a safe space to take responsibility is an easy thing to do. So I'm not actually sure what would be needed to get people to feel they could confess. Some judges have actually suggested removing the parents from the court hearing, because young people might feel more safe to confess if their parents not there. But of course, there's the whole problem that, I mean, parents are there specifically also for the safety of young people. So I don't really see a way out of it at the moment. Yeah, technically speaking, when reading the full question, I think you are right. In child protection cases, the question is whether a child is in danger, but all these elements about raising children, they all count. So if you look at those whole files of child protection cases, for example, it's not just about the danger is often this sense of danger. There's a whole range of factors which are either threatening the child or strengthening the child. So it's like a cost and benefit analysis, you could say, or positive and negative sides of the entire social environment of the child, including the parents. So yeah, whether a child is raised in a specific way is part of this assessment of danger. And it may come up in, for example, that the way a house, whether there are enough bedrooms for children, might be important in the total picture of whether they're endangered or not. So it does, technically, it shouldn't play a role how children are raised, but it is part of the larger danger assessment.
Thank you, Anna. Okay, let me first share my screen. Okay. So hello everyone, as Anna said, my name is Nina van Capelleveen and I'm a PhD candidate of the Department of Child Law of Leiden University since September 2019. And I'm doing a PhD research on the legal aspects of the tackling of radicalization of children in the Netherlands. And in this presentation, I would like to tell you something more about my PhD research and share with you some preliminary findings, a definition of radicalization. And although there are many possible definitions of radicalization, one that is commonly used by the Dutch government, for example, in the Dutch counterterrorism strategy, is the process of increasing willingness to accept and perhaps violently act on the most extreme cases of the most extreme implications of an ideology. So this is one of the possible definitions. And when children are showing signs of this process of radicalization in the current Dutch system, they are discussed during so-called multidisciplinary case conferences. And these case conferences, these multidisciplinary case conferences are organized by municipalities to share information about radicalizing individuals, so adults as well as children, and to make tailored action plans to tackle the radicalization of that individual. And these case conferences were originally designed to talk about or to respond to jihadist radicalization, but currently they are also starting to discuss other forms of radicalization, for example, right-wing extremism. So although case conferences are organized for both children and adults, one of the main differences between a case conference about a radicalizing child and a case conference about a radicalizing adult lies in the organizations that are present during the case conference. Key partners of all case conferences are the municipality, the police, and the public prosecution service. And in the specific case of a radicalizing child, the Child Care and Protection Board and someone from the Youth Care Center are also present. So that is one main difference between a case conference about an adult and a case conference about a child. And as I said, during a case conference, action plans are made to tackle the radicalization of a child. And in the context of these action plans, different legal interventions based on different fields of law are available for the partners of a case conference to respond to the radicalization of a child. If a child can be, for example, seen as a threat to national security, the partners of a case conference can request to impose administrative preventive measures to limit a child's freedom of movement. Such preventive measures are, for example, an area ban, a ban on contacts, a ban on leaving the country, or a requirement to report for the child. And next to this administrative preventive measures, juvenile justice proceedings are available for the public prosecution service when a child is 12 years or older, and importantly, only if the child is suspected or commits criminal offenses. And criminal offenses with a link to the radicalization of a child are, for example, training for terrorism, participation in a terrorist organization, or incitements. And next to administrative preventive measures, so next to administrative law and criminal law, civil child protection orders can be applied on the request of the Child Care and Protection Board if the radicalization of a child leads to a serious threat to his or her development. For example, as we have seen in the past, when a child is willing to travel to foreign conflict areas, for example. So these are very briefly the legal interventions that are available for the partners of a case conference when a child is radicalizing. And from these available legal interventions, the employment of a specific legal intervention in an individual case, and thereby the employment of a specific field of law, has important consequences for the individual child, arising from the nature, design, and legal character of the different fields of law. In administrative law, for example, a child is seen as a threat to national security while in child protection law, the child is mainly the subject of protection and care. And besides, the specific field of law that is employed in an individual case has an important influence on the position of a child and the degree of legal protection. So where a child in administrative law is in principle treated the same as adults and the same procedures and regulations apply, civil child protection law is specifically designed for children. It's specifically made for children. And a child is, for example, apart from a few exceptions, not competent to participate autonomously in the civil law proceedings. And juvenile justice, finally, lies somewhere in the middle of these two, in this context at least, because it is, to a certain extent, it has child-specific provisions, although the most provisions are the same for radicalizing adults as they are for radicalizing children. And these differences in the legal interventions do not only have direct implications for the individual child, they also touch on and have an influence on the extent to which the response of the government to radicalizing children is in accordance with the relevant international children's rights framework. From this framework, three core interests can be distinguished that are at stake when a child radicalizes. These core interests at stake are the protection of public safety, protecting children against threats to their development, and when interventions are imposed to safeguard the first two interests, a third interest is also at stake, namely protecting the fundamental rights of the child against interferences by the government. So when tackling radicalization of children, a balance must be found between these three different interests at stake. And again, the employment of a specific legal intervention that is applied in an individual case has an important influence on the extent to which the interests at stake are protected. So as you can see, the partners of a case conference have a crucial role when they decide about imposing or requesting specific interventions in an individual case. And when making these decisions, the partners have a wide discretion and there is a broad legal framework. Therefore, for my PhD research, I conduct semi-structured interviews with the partners of case conferences in 4 locations or municipalities in the Netherlands to explore how decisions are made and what interests are pursued. And so far, 13 interviews were conducted with mostly police officers and employees of the Public Prosecution Service. And for the last part of this presentation, I would like to share 2 preliminary findings from these first 13 interviews. And the first is that the interviewed partners of a case conference seem to follow a rather practical or pragmatic approach with regard to the interventions that are applied in individual cases. So when making up action plans, the interviewed partners of a case conference often mainly have a focus on the question which partner in this specific case has the best entrance or the best possibilities to reach out to the child. So one of the interviewed public prosecutors, for example, said that the partners of a case conference during a case conference look, and this is my own translation, very casuistic of what is going on and which of all these participants actually has the best credentials to reach that person. Because the goal is the same for everyone, namely that the process stops and goes in a different direction, if you can still influence that. So the interviews so far show a really goal-oriented and practical approach by the interview's partners of a case conference. And the second preliminary finding is somewhat an extension of the first, namely that although different partners work together during a case conference and they share information and they together make up an action plan or draw up plans of action, this does not necessarily or automatically mean that the partners also fully compare and weigh the possible legal interventions against each other to reach a balanced decision. And an important reason for this is that not in all cases, all or multiple interventions are available, given their legal grounds. There might be no criminal offense, no threat to public safety, or the radicalization might not lead to the necessity of child protection order. So in some cases, there is simply less or nothing to compare. But besides these more legal reasons, the first interviews also show that there are more practical or organizational difficulties in reaching a balanced decision. One of them lies in the secrecy of a criminal investigation. Criminal investigations are often kept secret from the other partners of a case conference, given the interest of the criminal investigation. So partners often don't know about the criminal investigation. And when they are informed, the investigation has often already started. So that makes fully comparing and balancing the different legal interventions more difficult. And furthermore, the people that are present at a case conference are often not the ones that actually decide about imposing the legal interventions. And information from a case conference is, because of privacy reasons, not always shared outside the case conference. So the first interviews show that the decision to impose a legal intervention or not are often made outside the context of a case conference. And these decisions are, by the interviewed partners, often highly concerned as autonomous decisions of the individual partners or the individual organizations. So this again makes it difficult to fully balance and compare interventions during case conferences. So someone from the public prosecution service, for example, said during the interview, and again, this is my own translation. It's not going further. Now it is. The decision whether or not we will prosecute, of course, lies with us as the public prosecution service. And every organization has in the same way powers that they may or may not use. But talking about this and aligning ultimately helps, also helps in making a certain decision. So this respondent talks about aligning interventions, but from this quote, it is also clear that the individual partners decide about legal interventions, not the case conference together. So these are two preliminary findings about the first 13 interviews so far. And they show that although various legal interventions can have very different implications for an individual child, these differences are not or cannot always, for different reasons, fully taken into account when deciding about the most suitable legal instrument. But again, these are just preliminary findings. More interviews are still being conducted, also with other partners of the case conference, and the data will be further analyzed. So thank you so far for your attention, and I'm looking forward to answering your questions.
Thank you very much, Nina, and I apologize for my Dutch pronunciation. I
Sure.
think I got Yannick right in the beginning. There is a question in the chat.
Well, that's okay.
Capelleveen, yeah, I'm getting better. Nina, will you also interview social workers who are closely involved with these young people? Question from Stephanie.
Stephanie, yeah. I will interview the people that do the family supervision order. So if there's child protection order, I will interview them, and mostly those people are the same as the child probation officers. And if they are involved with a child, they are also part of a case conference. So I will also, I will also interview them. I have a couple of them planned yet. And for some other organizations, my aim is to also speak to them. Yeah.
Okay, is there someone who would like to ask a question, maybe orally? Well, there's no one manifesting. Then I will ask a question. Yeah, the way that how you presented this case conferences works, it reminds me also a bit of how out-of-court disposals work in this setting of several partners coming together, but the public prosecutor that takes a decision. So I wonder, what is the role of the public prosecutor? Are you going to look at it further, and what is the relationship with the police in this respect?
Yeah, so their role is maybe a bit double. On the one hand, they're always present at a case conference, although there is no criminal offense or no criminal offense yet. So they are always present. They're one of the key partners. So they always sit at the table at the case conference to talk about a child and to see what's most fitting during or for a child to tackle the radicalization. And if there's a criminal offense and or criminal investigation, they're also in charge of the criminal investigation and the prosecution. So that's a very interesting role, and I will further look into that, because, as I said, the criminal investigation cannot always be shared. And I also asked during my interviews, for example, to a public prosecutor, what do you do about the information, what you hear during a case conference? Is that of influence on your decision to prosecute or not? And the reactions are very, very different. Some say, no, those are two entities that are not together. The entities are separate from each other. And others say, no, I get very useful information, so I take it with me during my decision about the prosecution or not. So that's their role in the police. A bit the same, except that they are more in charge of the criminal investigation and they do not decide about the prosecution or not. But they also have this double role of giving information and talking during a case conference, and then maybe a separate criminal investigation.
Thank you.
Thank you, Anna, and thank you, everyone. I have to say, I'm absolutely delighted to have been invited to reflect on these presentations in this second panel. But I have also just want to say I've really enjoyed all the presentations of the conference so far. It's been a really stimulating experience, so thank you. I mean, I have been making loads of notes based both on my reading of people's abstracts, but also on sort of the information that came up in the presentation. So please forgive me if I'm a little bit disjointed in the points that I make. But I do want to say that, you know, I feel that all of these papers are really interesting because in addition to the structural vulnerabilities of a child's minority status in society, they engage with additional situational vulnerabilities, many of them in relation to children's sort of ethnic, religious or cultural backgrounds, and also their sort of precarious citizenship status in terms of asylum seekers, and other sort of maybe linguistic inhibitions or disabilities too. And I think that recognition of these differences, as actually Yannick's paper just finally identified, illuminates the increased vulnerability that these children face, not just because of the inherent power differentials between children and adults, but also because of either the potential gaps in understanding of cultural difference or misperceptions of cultural difference, or a reluctance, as Iris identified, maybe to engage with some of these issues that may be relevant. So I just wanted to comment on a few of the, on each of the papers, just briefly, if I might, because I thought they were so interesting. Stephanie, I was really taken by your presentation of some of the deliberations of adults in asylum procedures. And I did think very much when thinking of the rights framework, that as well as participation and information, there is underpinning a lot of this something to do with cultural understanding. And in the sort of the work of immigration officers, you know, you become very aware that they are engaging in an assessment process in this and that their understandings of culture and background are going to be critical. So it's not just listening to the child, but it's also recognizing the particular understandings that these officials have about the backgrounds that the children come from. And I think the other thing that really struck me in your presentation was your observation that participation is not necessarily an easy process. In fact, it can be incredibly stressful, and given the backgrounds of these children, possibly re-traumatizing too. So I think that really adds a sort of a question to rights frameworks, which you know, make that assumption that participation is you know, is something that should be vaunted. And I'm not saying it shouldn't be, but I do recognize that actually there are conditions where, in fact, children have the right not to participate, and that is something that maybe sometimes we overlook too. Iris, I was fascinated. I thought your presentation really shows just how much legal decision making is infused with values, and I was really taken by sort of the examples you gave, and the one about the fact that some young people in the criminal justice system do not sort of confess or do not show remorse in their crimes, was something that actually has been picked up, and I think Yannick, in some of your research, the idea that it's not necessarily just about culture and background, but it may also be about perceptions of the criminal justice system itself. So that mistrust or lack of understanding of the way the process operates. And certainly in UK, David Lammy, in his review of sort of minority ethnic experiences, identified that there was a higher proportion of no guilty pleas and amongst sort of Black and ethnic minority groups, and he identified this as linked to a lack of trust and confidence. If I say I've done something wrong, or if I say, you know, if I make any admission of guilt, then I'm actually going to end up in a situation that you know, a much worse situation. So I think it's really interesting to think about issues to do with the perceived legitimacy of the system, perceived understanding of the system, as well, in that sort of absence of confession. I was taken too by the idea of sort of conflicting values in what constitutes maybe a good parent or a good parenting in sort of social work orientation. And I'm very conscious that, you know, in human rights frameworks, there is deliberately some wiggle room, liberal wiggle room, we might say, to allow for difference in values. But of course, what your research highlights is where those values can come into conflict, and the challenges around not addressing them or not recognizing them. And you have intimated that you're interested in exploring the idea of sort of color blindness and racism, and I think that's a really relevant issue to explore, the extent to which we engage with issues of difference, and if we do that, we recognize difference as potentially being a source of discrimination. But by drawing attention to that, do we then somehow stereotype or reify difference in a way that makes practice more sort of difficult to engage with normatively? And yeah, so as just thinking of Yannick's presentation there. Nina, I think you're engaging with a really topical issue. At the moment in Northern Ireland, you may be aware there are riots, and there's a lot of conversation about how young people are being sort of caught up in sort of bigger projects, you know, by possibly because of exploitation by adults. We also in England and Wales are sort of engaging with challenges around the involvement of young people in county lines drug distribution networks, and the idea that they are becoming involved somehow through their connections with others. But there is an interesting tension there, I think, in relation to whether we, you know, these ideas agency and vulnerability. And I would like to question, I think, the conceptualization of the radicalized child. And what does that mean? And what are the consequences for that definition in terms of how people engage with that child? So, I mean, within the County Lines remit, there is this sort of parallel tensions between offenders and victims. You know, is the child, as a drug dealer, are they an offender, or are they a victim of sort of a larger sort of exploitative network? And there is referral under our Modern Slavery Act to what's called the National Referral Mechanism for consideration of victimization. And I'm just interested that in your presentation to date, that wasn't a narrative that was so obvious. So I think that's an interesting area to reflect on. I think also, and I was mindful, thinking back to Anne Skelton's earlier comments about the situational definition of vulnerability, that when a child is considered at risk to the public, the legal focus is on the child as an individual, and therefore attributions and actions around changing the child as well as changing their situation. Whereas interestingly, when we only define the child as vulnerable in other contexts, the focus is more on changing the situation, necessarily on changing the child. So I think there is a really interesting sort of conceptual distinction to draw there. And I think the only other point I would make, and which you drew attention to, was the sort of interactions between different agencies and the sort of the different perceptions that agencies have. And I think, Anna, you also picked up on that in your question. And certainly, you know, one can think about how these different agendas that maybe the police have for prosecution and youth justice or welfare workers have for protection, how those play out in sort of the nitty-gritty of sort of practice. And then Yannick, I mean, I'm familiar with your research, and I'm you know, delighted to that you have sort of been instrumental in inviting me along here. And I think, you know, a lot of what you say about equality and the application of some of these sort of broader principles into practice is really really important. And I am very much reminded of Amartya Sen's distinction between justice as niti and naya. And I don't know if you're, I mean, you may remember this, but he draws attention to the distinction between what we hope, or what we justice in theory, so the ideal institution, if you like, and then justice in practice, you know, the naya, if you like, of the fact that, you know, institutions, we need to look at institutions in terms of what they actually achieve, as well as what they espouse they want to achieve, in order to really get to the sense of equality and justice and non-discrimination. So in a fascinating range of papers, I think a couple of sort of general points that I would want to identify. One is that I think in all of these papers, we become very aware of the child in situ, so the relational situatedness, if you like, of children. And you know, this is something that sociologists such as Spiro and the sociology of childhood have drawn attention to. So the child is very much in a network of relationships with their family, peers, but also with the court and their interactions in the court. And I think that what's interesting with taking that perspective is then to think about the individualized nature of rights and the extent to which maybe there is a room for further consideration of the child's relational self in the sort of in the development of rights perspectives. And then finally, I would just like to also think about, the role of temporal perspectives and their intersection with cultural and ethnic differences, and also with children's physical and psychosocial development. And I mean this from two respects. One is that I think it's relevant to take note of the fact that cultural values, any sorts of values and beliefs, are dynamic. They're dynamic amongst communities. They're dynamic within individuals as well. We change our views as we as life, you know, as we go through life. And I think, therefore, this points to the importance of process. So the idea of ongoing communication and dialogue, in order that we understand where values are at the moment, in terms of communities at the moment, but also individual children at the time. And then a final point is relation in terms of time, is thinking not just about children's rights in the present, but the relevance of legal decision making in the present for children's rights in the future. And these, I was particularly struck going back to Nina, your presentation, because of course, if we identify or label, in criminology, we talk about labeling, if we label a child as radicalized, we then set up the potential for their future selves to be limited. So I think it's interesting to think about the longer term implications of legal decision making in the present for the rights of the child in the future. Okay, so lots of things there, lots of food for thought, I hope. You know, as I say, thank you again for giving me the opportunity to talk and to offer my views. You know, these really were very high quality and thought-provoking papers, so I hope that you find my observations of interest. Thank you.